All right, good afternoon. Let's begin the third panel. I think we are having some difficulties with the time constraints, so I think we should move forward. This afternoon, the third panel is entitled Restructuring Government Debt Using Chapter 9 Principles. I have the privilege of being in the panel with Mr. Zack Clement. Mr. Clement is a partner in Fulbright and Jaworski, and to be honest with you, it's easy to be in this panel when you have such a captain. He will take care of taking us through this trip, and I think we're going to have some fun. I will allow Mr. Clement to take the podium and begin the conversation, and I will follow the lead. Zack.
Every one of you knows why it's worth listening to Nelson Robles talk. And so here's some guy from Texas at 4 o'clock in the afternoon, and I'm asking each one of you to get out your pen and your piece of paper and write down 9 things. The first one is that Puerto Rico is in the news as having trouble paying its bond debt, and Puerto Rico is not by itself. You are not alone. A lot of major cities in America cannot pay their bond debt and their pension debt at the same time. You all are simply the one about whom it's being discussed a lot. And most countries in Europe can't do it either. You are not alone among governments. That's number one. Puerto Rico is having trouble paying its debt, and it's not alone. Number two, in a Chapter 9 case, there are no shareholders. Know what that means. There are no shareholders, so there's, as a practical matter, no real absolute priority rule. As a practical matter, that means there will be debt discharge as to unsecured claims. No shareholders, debt discharge. That's item 2 on the list that I'm encouraging you to write down. Whatever method you wish, keep these notes, because as we go along, the notes will become more meaningful to you. Number 3. Lead like a debtor in possession. I'm not suggesting that anybody dance like Jagger, but I'm suggesting that they lead like a debtor in possession. You think what that means? Debtor in possession has an exclusive period to propose a plan and get it confirmed. And what I say to every debtor client is, they give you the right to lead, use it. Don't come to the end of the exclusive period and we still don't have a plan. Use it. Lead with a plan. That's number 3. 4, get in shape, cut costs, come up with a plan that's fair and equitable. What does that usually involve? Figuring out how much you can afford to pay and formulating a plan based upon it. So that's number 4. 5, think about what contracts you're going to reject. That's the first cousin of cutting some costs. We're now talking about actually rejecting some contracts. And I will take a little pause here and say, in most every municipal restructure that isn't done in Chapter 9, what happens is it's done by focusing on labor costs and focusing on reaching labor contracts. Even in Chapter 9, A, cut costs, B, think about what things you're going to reject. So number 5 in this list is what contracts to reject. 6, what's really secured? There are a lot of people that think they have a security interest in something or other. Do they really? Is it perfected? And here's the important one. Are they fully secured? Because I submit to you, in many cases, the collateral is worth nowhere near as much as the debt, and a substantial portion of what people think is a secured claim is actually an unsecured portion of that secured claim. That's 6. 7, we just described how you create the general unsecured claim class. You figure out what contracts you're going to reject. You figure out what people are really secured and whether they're undersecured. And what's left are the unsecured claims, which when combined with the labor contract rejection claims, create your unsecured claim class. So 7 is, what is your general unsecured claim class? 8, pay them what you can afford. We're back on item 3 or 4, cut costs. Cut costs. Figure out what you can really do to generate more cash flow so that you can afford to pay more on your debt. But now we're down at 8. Pay them what you can afford. Comma, and the rest gets discharged. That's what happens in the Chapter 9 case. You pay them what you can afford, and the rest gets discharged. 9. You might notice I made this come out to 9 since we're talking about Chapter 9. 9 is, what in this ballpark can Puerto Rico do? And we'll get to that last. Now we've got this PowerPoint here. It starts in the first 3 pages of the PowerPoint with a quick overview of the whole Chapter 9 process. There's a middle part that talks in detail about some of those things, and then there's a part at the end that talks about what does this mean to Puerto Rico. So just like this list of 9 points I kind of leaned on you to write down, first 3 pages is crucial because it's the summary. And we'll start with first 2 here. Got to prove that it's a municipality and prove that it's authorized to be in the case. Nelson, lead us on that.
Good afternoon again.
You want this one?
Yeah. All right. Working in this panel to me is like walking into Apache territory, because Zack, maybe Patrick, Jerry, you guys have seen maybe this creature before, but none of us here in Puerto Rico has ever worked in a Chapter 9, and I guess during the discussion we'll find out why. But to me, it's a very interesting chapter. It's a short chapter. You can read it very easily, but it's extremely complicated, and there's not too many cases out there that you can refer to and work with. There are some, maybe lately, but not too many. The first thing I'm going to do is discuss under Section 109 of the Code, 109C, you have to demonstrate if you fall under the category of being a municipality. And it's defined by the code to mean a political subdivision or public agency or instrumentality of the state. And as to public agencies which are not defined in the code, usually they are instrumentalities of the state, or they refer to independent corporations, board, districts, authorities, and commissions that are organized to construct and operate public projects. To me, an interesting part of this section of the Chapter 9 will be to, by the way, that definition comes out in Section 10140, which defines the municipality. You need to make sure that you're authorized to file under Chapter 9. How you do that? Usually by statute. If you look at all the 50 states, most of them have statute. But last time I checked, there are like maybe 23, 24 of them that they don't have statutes that will allow the municipality to file for bankruptcy under Chapter 9. As a matter of fact, I think Georgia have some specific statute that will prohibit the municipalities or public instrumentalities to file. The reason for them to do that, well, I have no idea, but they have it in there. And in these cases, I think the first litigation, first year of litigation, would go into that direction. Are you allowed under the statute, the state statute, to file for bankruptcy? And if you look into the cases, there's a lot of litigation in there, people trying to demonstrate that even if you have the statute, it doesn't comply with what the courts are stating you should comply, and you're not allowed to file. So that first part of the case, which is when you file, you will confront a lot of litigation into that direction. I think, Zack, you will take, if it's insolvent, and the other two in that page.
Nelson, I'm going to take us forward to page 6 in the outline. These are the statutes that talk about being a municipality of a state.
Zack, I'm sorry to interrupt. Microphone.
These are the statutes that talk about being a municipality of a state. Now, Nelson went through this before, but it's worth staring at this. A municipality is a political subdivision of or a public agency or instrumentality of a state. That certainly applies to cities. It would probably apply to corporations wholly owned by the Commonwealth of Puerto Rico. But look down here, how a state is defined. Includes the District of Columbia and Puerto Rico, except for the purposes of defining who may be a debtor under Chapter 9. God knows why Congress chose to discriminate against the state or the Commonwealth of Puerto Rico. God knows why. But that's hard to get around. That's a federal law that says that Puerto Rico doesn't have the power to authorize what I refer to as its children to go solve their problem. Why they did it, I don't know. Whether you can get around it, I don't know. Nelson actually has some really innovative ideas about that. Do you want to comment on that?
Sure. If you look at the legislative history of this chapter, you won't find an explanation, a rational explanation as to why they left out Puerto Rico in that section, specifically stating that under 101.52, we won't be able to participate or use Chapter 9. The only thing you will find is a law professor commenting in the floor of the Senate, stating that he doesn't understand why they decided to keep Puerto Rico out of this section, but that he understands that should not be a problem, that it should be there. But at the end of the day, they passed the legislation as it is. I personally, I think when you're on a panel, you have the right to say things that nobody will believe, but I think I'm going to use that now. I think, and I think I have commented this to other people, that it would be, if you can find a municipality in Puerto Rico that is willing to take a test case to the court, I would think that you can do that, and the first fight would be to present a constitutional issue in the matter, saying we have the right to be there. There's no rational test in order to exclude Puerto Rico. I think we can go as far as going to Califano versus Torres, which is a 1978 case, which at the time was related to Social Security, and the issues presented there bring to me something similar as the rational test. But again, you will need to find someone to be willing to do that, and that's not that simple here in the island, either from the present administration or the past administration, to find maybe a municipality or a corporate instrumentality that's willing to do that. That's going to be tough. But I think, if you ask me, that's what I would like to do.
I haven't told Nelson this, but I've made Nelson an honorary Texan for creativity and audacity, and I love his courage. And I'll stop and say, apparently there was a question back there. Go ahead.
So does that one that understand that the other U.S. territories, the USPIs, like Guam, American Samoa, etc., so forth, would they be able to avail themselves under Chapter 9?
Well, the answer is it's not clear to me, and the Retirement Fund of the Northern Marianas Islands filed a Chapter 9 case, and it was dismissed on a technicality of this sort. So it's not clear to me. I think that's a good answer. That's as much answer as I have.
When was this section legislated?
I believe it's been there since 1978. I think so. Now, let's go back to...
There's a question, Mr. Gubrin.
Sure. Within the definition of a municipality, would you say that a public corporation, aside from the Puerto Rico issue of its state, would qualify to file a Chapter 9?
In Zack Clement's opinion, yes.
Yes.
But the problem is with this definition of state.
No, exactly, I follow you.
But on the other one, my opinion is yes.
Zack, I've been asked to, whenever we have a question, to repeat it so it comes out.
Happy to do that.
Right.
Next. If there is no next, I'm going to take us back to page 2. Is it a municipality? That's the derivative of, is it a state that it's a subcategory of? Is it authorized? It can be done by a statute. In 2 cases, New York off-track betting and the city of Detroit, it was done by the governor of the state, not by a statute. So it's very clear that a governor can do this. That it is insolvent, defined as is generally not paying its debts as they come due, and is unable to pay its debts as they come due. The first one is supposed to be present tense, is not generally now paying them. The second one is supposed to be somewhat prospective. Pretty soon there'll be some big liability so big you can't pay it. This comes up a lot with discussion of pension liabilities. And let me give you a flavor of this. There's one city in America, Detroit, that's in a Chapter 9 case, and it has 9 billion of bonds and 3.5 billion of unfunded pension liabilities. There's another city that has this worst problem in America that has 20 billion of bonds and 20 billion of underfunded pension liabilities, and in 5 years that number could go much higher than 20 billion. So with a city of that sort, one of the questions is, how long is it going to be before you will be unable to pay your debts as they come due? Now, it's worth talking under 3, is not generally paying, the following public policy problem. As I said before, what governments everywhere tend to do to resolve their insolvency is to aim first at labor, lay people off, reduce wages, try to reduce things that are already owed to labor. It doesn't take long to figure out by listening to me that I find it unfortunate if only labor gets leaned upon. So suppose the city decides we're not going to lay off 10% of our workforce, we're just going to pay them all 90 cents on the dollar and be in default for the other 10%. That would be generally not paying your debts as they come due. My point is that this issue of insolvency is one that's very fluid, and a lot of wasted time is spent in these cases arguing about it. But when you can't pay all your bills without making such cuts that you're not really serving the citizens anymore, it's not, in my view, that hard to show that you're insolvent. Although people who don't wish these cases to go forward love to fight about this issue. That it wishes to restructure its debt, it's an odd standard. As far as I'm concerned, if you ever file a Chapter 9 case, it should be after you've come up with a plan, sold it in public for a year, got some people to support it, others that won't, you force it on those that won't. And so everybody has known what your plan is for a year, and you file a plan on day one. Isn't that proof that you intend to restructure your debts? I think this one's very easy to prove also. The next one is essentially, have you behaved right in the period leading up to the Chapter 9 case? Did you either get agreement with majorities in all the classes you want to force the plan on? When I say force the plan, you're really talking about forcing it on the few holdouts, or however many holdouts. Or have you negotiated in good faith? Or are further negotiations impracticable? Move to the one in good faith. I've been through this once in a city in California. The other side that didn't want the case to go forward wanted to argue that we were not in good faith because we hadn't cut all the services and raised enough taxes to pay them in full, so we couldn't be in good faith. We couldn't go forward. It's kind of an absurd view of what good faith means. Those same people refused to come to a pre-bankruptcy mediation that was required by California law. My answer was, thank you, because you've just proven it was impracticable to talk to you because you wouldn't show up. So my point is, these two are ones that people like to fight about. The reason they like to fight about them is they don't wish to ever get to that trial about how much you can afford to pay, and so they fight about all of these things. print's small, but I think you can get the point. 903 says that the state shall not lose its control over the political activities of its municipality that it authorizes to go off to Chapter 9. 904 says the bankruptcy court shall not interfere with the way the Chapter 9 debtor uses its property unless the Chapter 9 debtor consents. For what it's worth, the reason those two are in 903 and 904 is that they're a pretty good paraphrase of what the Supreme Court said in U.S. v. Beacons in 1937 when it upheld the constitutionality of an amended Bankruptcy Act for municipalities. And the issue is, can the state give up some of its sovereignty by letting its municipality go be in a Chapter 9 case? And the answer there was that since the state didn't lose its political control over its municipality, and since the bankruptcy statute then at issue in 1938, just amended, didn't permit the court to interfere with the way the debtor ran its business, except on whether it confirmed the plan or not, that the statute was okay. So those are very important to the constitutionality of a bankruptcy statute that we now have. Chapter 9 cries out for a municipal debtor to lead by proposing a plan. I think that was item 4 on the list. Item 3, lead like a debtor in possession. Lead like a debtor in possession. A creditor cannot file an involuntary Chapter 9. Chapter 9 case cannot be converted to a Chapter 7 liquidation. Think about that. You can't liquidate a city. You can't go sell its assets and tell everybody to go someplace else. Can't liquidate a city. Only the municipal debtor can file a plan. That's in keeping with 903 and 904. The bankruptcy court can dismiss the case if it wasn't filed in good faith and if you don't make progress toward confirming a plan. So lead with the plan that's fair and equitable and confirmable. Three fundamental confirmation standards. These are worth writing down too. I'm the pushiest guy you ever heard from Texas. Feasible, fair in interests, feasible, best interests of creditors, and fair and equitable. And oh, by the way, Lyndon Johnson was pushy too. He was a great president. Anybody figured out which party I belong to?
Steele?
Feasible. Nelson, tell us about feasible.
Let me just interject and go back a little bit to what you were saying. I think we have to bear in mind that different to the other chapters that we handle every day, the court intervention in Chapter 9 is totally different. To me, it's like maybe like a traffic controller. It can't tell the government or the municipality in the case what they're going to do with the assets and so forth. So I think that's important in the feasibility aspect, because even though you have to present a feasible plan, as you explained, that you have to plan beforehand, maybe work with it before you go into a Chapter 9, you have to present a plan that will take care of the creditors in a reasonable manner, but you have to show also that you will be able to comply with your constituents and provide all the services that usually the municipality provides to the people. In other words, you may have a great plan, but if you don't show that you're going to keep on providing the services, you won't be able to confirm it. And I think in that sense, it's very unique and very interesting, because then you will see the role of the court that cannot tell the municipality how are they going to do that, how are they going to provide the services. Maybe the court will interject as to, will this fly, will this be a feasible plan, but it won't be able to tell the municipality how to do it and what services will be able to cut or not cut. So to me, that's a big difference of what we do here in our jurisdiction.
So I went back one slide. Unless the debtor consents or provides in a plan of debt adjustment that only it can file, the court may not interfere with any of the political or governmental powers of the debtor, any of the property or revenues of the debtor, or the debtor's use or enjoyment of any income-producing property. This suggests that you've got a vacuum that you should fill with leadership toward a plan. The other thing about feasibility is the cases discussing it say you can't liquidate a municipality. We're not going to talk about selling off all of its assets and telling people to move someplace else, and it needs to have enough money left to do what it's supposed to do. I was at a seminar recently and somebody from the audience said to me, well, doesn't a municipality owe fiduciary duties to creditors? And I said, I'll tell you who a municipality owes fiduciary duties to: citizens. And that is implicit in the decisions about feasibility. You need to have enough money left to do what you're supposed to do as a government. Best interests of creditors. It's a floor. And I will simply say, this is on a later slide, but I might as well just say it now. 1129A7 that says you do a best interest analysis by assuming there's a Chapter 7 liquidation is not made applicable in Chapter 9. Because, did I say this before, you don't liquidate municipalities. You don't figure out hypothetically how much people would get if the municipality's assets were sold. You don't liquidate municipalities. What the best interest test means for a municipality is assume the case is dismissed, creditors get to go off to court and use their remedies. In most cases, what the remedy is mandamus, which in the Asbury Park decision, Justice Frankfurter referred to as a meaningless right to litigate. Now, there's a reason he said that, and he describes it at greater length. First off, mandamus is probably as far as any legislature went in waiving sovereign immunity to permit you to do something versus this government entity. Secondly, mandamus is a court telling the executive and legislative branches how to behave. Implicit in that is some level of restraint. Finally, is the concept of how long does even that mandamus remedy last? Because a number of people say that since I think I have a claim against certain tax revenues, in essence I can collect them for 100 years, causing me, being from West Virginia, and in my cultural understanding, to say this ain't amazing grace. Where the line is, when we've been there 10,000 years, and it goes on, you don't get to collect these things for 10,000 years or 100 years. In the two states I've looked at, Texas and California, it's 10 years, and maybe it's extendable to 20 years. So when you start talking about a best interest of creditors standard, it isn't liquidation value. It probably is what do people get if they pursue mandamus. Mandamus is notably not a very good remedy. And you can't pursue it for all that long. And so if you do a best interest of creditors kind of analysis and testimony, the answer is going to be that floor is not going to be very high. So now we're back to the one I liked to talk about before. Propose a plan that's fair and equitable, because that really is the standard. Nelson, tell us about fair and equitable treatment of secured claims.
Well, the summary that you have there basically takes care of the matter. You have to exactly do that. You know, the secured claimants need to be treated fair and equitable, and either you pay them the value over the time, you abandon the collateral, or you sell the collateral with the right to the credit bid. I think most of the litigation in that aim will go to Section 552A, and is a very complicated subject. Here in our jurisdiction, if that will be the case, if we have someday a test case, we will be dealing with the contractual liens and maybe statutory liens. I have never seen, at least in the States, too many special revenue liens. But you know, the gist of the matter is that if you provide them with a fair and equitable treatment, you'll be fine. In that sense, with the secured claims.
Now, this is a litany you heard from me a moment ago. So fine, maybe they have a lien. But as we all know, your secured claim goes only to the extent of the value of your collateral. And it's really a combination, if you want to know the value of your collateral, it's a combination of your remedy and the inherent value of the collateral itself. And as to the remedy, you've heard the litany. Is it anything more than mandamus? How long can it be exercised? And oh, by the way, what's the value of this collateral? My favorite one is, what's the value of a city sewer system in a foreclosure sale? Who wants to bid for it? So there are a lot of folk that may end up being undersecured, is my point. Fair and equitable treatment of unsecured claims. Carmen did a beautiful job earlier of describing the absolute priority rule. It says, unless unsecureds are paid in full, nobody junior can get anything. But remember I said, there are no equity holders in a city. And so, for all practical purposes, the absolute priority rule doesn't apply, because there's no one junior to unsecureds who will ever get anything in these plans, because there is no equity holder. Only one bankruptcy, just a second, only one bankruptcy code case has ever applied the absolute priority rule by those literal terms. And what it said was, we apply it that way, and oh, by the way, we're going to now do a good faith analysis, and that good faith analysis was exactly what is the rest of what I'm describing here. So frankly, no one has ever applied that absolute priority rule to give a municipal debtor a complete pass on proving that it has paid all they can reasonably afford to pay to unsecured creditors. Yes, sir.
Yeah, I had a question about, you say the absolute priority rule doesn't apply because there are no equity, no shareholders
Correct.
in the municipality, which I understand. But if you classify by, if you have different bondholders, you have different classes of creditors, don't you have to respect the absolute priority rule between those classes?
Can you repeat the question, please?
He said very nicely that I had said that the absolute priority rule doesn't apply because there are no equity holders. But what about priorities among unsecured bondholders? Don't you have to accept those? First off, what I should have said is the absolute priority rule applies, but it's largely meaningless because there are no equity holders. Second, of course it applies if there are legitimate priorities among bondholders, but I underline the word legitimate because I think in many cases they're all just general unsecured claims who are not necessarily entitled to any priority over one another, but that's a matter for individual fact analysis. But yes, it applies. It's just largely meaningless because there are no shareholders. Now, having said that, what is the test that they always apply in the few cases that have ever gone to a cram-down trial about this? Is the municipality paying all it can reasonably afford after reasonable austerity, reasonable use of taxation, with the rest discharged? And there are these cases from California in the 1930s where they looked very carefully at whether these municipalities were doing things they needed to be doing, whether they were wasting money on it, whether they had tried hard enough to use taxation. And that's the reason I go back to Number 4 in the original list, cut cost. Go through and be able to show that you had all the austerity you can take without ruining your city and your citizens' way of life, and that you've made adequate use of taxation. Now, there's one other issue that's not on this list here, but I'm going to describe it. It has almost completely understandably come up in Detroit, where creditors have said, you ought to sell the art museum. We think it's worth $2 billion and you could pay us. And there are all sorts of people in Detroit arguing that somehow the best interest test involves a floor premised on what you could get for selling the assets, including the art museum. Number 1, I don't think the best interest test requires any analysis of selling assets. Number 2, does that same issue come up here with respect to showing that the plan is fair and equitable? Do you need to show that, well, we thought about selling city assets, and here's why we kept each one of them, and here's why we chose to sell a few of them? And I was in a room full, I could perceive, of New York bankruptcy lawyers, and someone wanted to raise this issue. And I knew what they were really getting at was the Detroit Art Museum. And so, being from Texas and being somewhat obstreperous, I said, well, let's think about this being New York. Do you have to monetize Central Park? Do you have to sell all the real estate in Central Park, which is in a really expensive part of town, in order to raise enough money? My answer is you do not have to sell Central Park unless you make a judgment that's, as a political matter, that somehow the city is better off to do that versus not. And so my real point is, I think it's arguable whether having to monetize assets is a third item here, but if it is the third item, I think deference to elected officials and their judgment on this point is crucial and required. And if you want to see my statutory basis for that, look here at 904. Unless the city, in its judgment, proposes to sell some of those assets, I don't think 904 permits anyone to require it to do so. So that's the overview. And we have later sections that go into a little bit greater detail about the things you've heard already, but it's the original 9 things I talked about. You have to be authorized and have some proof in order to get into the case. While in the case, the court can't interfere with the way you run your municipality's business. You've got to figure out what claims you're going to reject, figure out which claims are really fully secured or even secured at all, create this general unsecured claim class, prove how much you can reasonably afford to pay, and there's your plan. Now, Nelson, how much time do we have left?
I think maybe 30 minutes. If we go all the way up to 6 o'clock, that's what we have. I think it's up to 6 o'clock.
In that case, let's go to page 20. So this is what you do if you're a government and you have solvency problems. Cut expenditures reasonably, cut services, cut number of employees, cut wages for work going forward, cut pensions already owed, question mark, cut other things already owed to labor. That's the litany of all the things you can do to get lean. Raise revenue reasonably, raise or lower property taxes. I know someone in Texas who argues in every one of these municipal cases you should lower the tax, otherwise you'll run people off. And it's actually counterproductive to raise tax. Consider selling government assets. You notice I put the verb consider in there. Stretch out secured and unsecured debt. Now I have a real important point. D, if you do this restructure under state law, you never get to D. We'll get to why that's true. D is reduce or discharge portions of unsecured debt beyond what you can afford to pay. And I repeat, if you do it under state law, not under federal bankruptcy law, you cannot get to D because states are precluded from impairing contracts. So we'll come back to that more as we go along here.
If the law that permits to reduce the debt is prior to the contract, is it still?
States cannot take actions that impair contracts. States.
Even if the law precedes the contract.
Well, then you get into an issue about whether the contract has to read the pre-existing law into account, and then it's not an action by the state taken later which impaired the contract. And so your point is very well taken.
See, we have a bankruptcy law here that dates back to 1889.
That's fascinating.
The civil code, and that's provide for discharge.
Does it provide for discharge? Now, that is fascinating. Now, I will say that one of the issues you're going to have with that is whether that law has sometime since then been preempted by federal law. But since, as we saw earlier, they have discriminated against Puerto Rico and said that that federal law doesn't apply to you, they might have opened the door for that law passed in what year?
That was the civil code in 1889.
God bless 1889.
It follows the code 1265.
Yeah, but it doesn't have regulations. No. You have to have rules and regulations. Otherwise, the statute is not binding.
Oh, that's interesting. Yes, sir.
Anyway, since you mentioned the Constitution, the Article 1 says that Congress should pass one uniform law for the whole nation. Now, does the exemption of Puerto Rico and the District of Columbia violate that Article 1 of the Constitution?
You have to repeat the question. So that
I can't.
No.
The bankruptcy clause provides, see if I do a good job, the bankruptcy code, or the bankruptcy clause of the Constitution provides that Congress can pass uniform laws. And since they have discriminated against Puerto Rico by leaving it out, does that mean that there is a constitutional violation? And all I can say is, you and Nelson will write this brief, and by God, I hope you win.
Well, there's another, you mentioned sovereign immunity. We have case law in the First Circuit that says that some of the government entities, for purposes of sovereign immunity, are not entities of the government. Can those specific corporations formed by law that have been held by the First Circuit not to be government entities file in Chapter 9?
Well, Chapter 9 or Chapter 11?
Oh, Chapter 11, I'm sorry.
Well, let me just say there is a case like that in Las Vegas monorail, for lack of a better way of referring to it, and the court found this thing isn't a Chapter 9 debtor. It then filed a Chapter 11 case.
That's covering your American bankruptcy law journal?
Do you have a citation for that case?
I can get it for you. And by the way, then you run into the problem that the absolute priority rule would apply. Because if it's a private corporation and the stock gets wiped out in the Chapter 11 so that the bondholders end up owning the stock of this state corporation, is that a good result? It's a different animal than a Chapter 9. Now, that said, what is Chapter 9? It's a process to let the debtor lead. Did I say lead 9 times already? I'll get to 15 before I'm over. Lets the debtor lead and provides a context to have a trial if people don't think the debtor is leading with a fair and equitable plan. Now, let me just back up a second. Those are the things you can do. I've said you end up stopping short of D if you do it under state law, except this gentleman back here has found a wonderful law from the 1800s. God bless him. Now, I'll say the heading to this and then turn it over to Nelson because he knows a lot more about it than I do. Puerto Rico has already had substantial austerity and cost cutting.
Well, I think you're referring now to some cases that have developed because of the last two administrations trying to deal with the crisis. I think in the materials you have the mention of that's 12, Roman number 12, number 3, the U.S. Second Circuit Court of Appeals ruled in Puerto Rico's favor, and that should be the First Circuit, not the Second Circuit. United Automobile Workers versus Fortunio. And in that case, basically, we go back to the issues presented by Act Number 7. At the time, the government presented a reform or reduction in 3 phases, and one of them was actually, dealing with some clauses that the plaintiffs understood were impairing the contract clause according to the federal constitution. They took the case to the First Circuit, and because of what happened, obviously, in district court, in which the district court, if I recall correctly, dismissed the case under 12b-6, stating that plaintiffs didn't present a claim according basically to, at the time, the ruling under ICBAC, which is the court from the Supreme Court stating how the claims should be drafted and so forth. And interesting enough, to me at least, was the fact that the burden of proof was placed in the plaintiffs different to the government, which was the defendant in that case. So it was a technical thing, and actually the government won that round by even, under my view, dealing with the contract clause under the federal constitution, but due to that technicality, they won. Things have changed a little bit. I think we have other cases, but they are not in the federal atmosphere. They are in state court. Basically, they are rulings or opinions from the Supreme Court of Puerto Rico. I think you mentioned one of them in your materials. That's the case of Hernandez versus Commonwealth. That's a 2013 case. And basically, in that case, you have, again, the government trying to work with some kind of reform. In this case, was related to the retirement system of the public employees. And you have, again, the issue of a contractual impairment versus allowing the government to provide changes to deal with the economic crisis. In that sense, in that case, basically, the Supreme Court analyzed the issue, and it ended up concluding that the evidence presented by the government was much better than those presented by plaintiffs. So again, at the end of the day, it allowed the constitutionality of the law. It makes some adjustments to part of it, but the government went along and have a good day. Things have changed a little bit. After that, in the year 2014, we have an interesting case which was filed by an appellate court judge. The case is known as Germán Brau versus ELA. That's you can find it in 2014 TSP 26. It's supposed to be out in 190 DPR. And that case has to do with the reform of the judicial retirement system. And needless to say, well, the government loses, and they won't be able to touch too much the judicial retirement system. Basically, it's a very interesting opinion because it goes all the way back to the analysis of the separation of powers, and the Supreme Court basically saying you can't do that with the retirement benefits of the judges that are actually in place and those that are already retired. You can maybe do some changes with those judges that will come into the system between December 2013 on. And to me, the way they analyze it, they didn't go into the impairment of the contractual clauses under the Puerto Rico Constitution, which I believe are under Article 2, Section 7 of the Constitution. They use a different approach, and basically they said you can't do that because you would be interfering with separation of powers. And the last case that I have, at least that I checked, is the one that came out recently in April of 2014, which is Asociación de Maestros versus Sistema de Retiros. That's in 2014 TSPR 58, and it will come out also in 190 DPR. And there, you have a totally different ball game. You have a totally different discussion. The Supreme Court actually goes into Article 2, Section 7, stating that the government is actually impairing the contractual agreements with the teachers, and they cannot do that. At the end, they struck down the legislation as unconstitutional, and they only allowed a small portion of it to go through. So, in my view, you're looking at a tendency of, at least the cases before the Supreme Court, of going into the legal analysis of the contractual impairment, saying to the government, if you're going to do this, you better demonstrate that you have no other way of doing it, otherwise we're going to struck it down. Yesterday I learned that the Senate is working on a piece of legislation identify of PS 993. It was drafted in March 2014. I understand right now is before the Committee of Hacienda and another committee of the government for obviously discussions in the floor with people they will invite. It's very interesting, and I shared with Zack last night, because it's a way of trying to use some wording of Chapter 9 only for government corporations. But again, if you read it, at least the version that I have, maybe that will change when it goes to the House of Representatives and they try to pass it as a bill. If they eventually do that, it will have some serious constraints on the contract impairments. In other words, they won't do that. They whatever they do in there and whatever they offer to the public corporations will stay away from dealing with any impairments of the contracts they are engaged with other creditors. And it also discusses the fact that if it doesn't work, they will liquidate the corporation. So at least from the examination of those cases from the Supreme Court and that piece of legislation that is supposed to be out there, to be honest with you, I haven't double checked what's the status of that legislation, but I know it's in the floor somewhere in some committees. They are staying away, at least, the Supreme Court and the legislation from contractual impairment. I think that's important because of what Zack is going to explain to you, his view of what other alternative we have out there, different from the one that I proposed, that it will be going with the test case to the bankruptcy court and let Judge Tester or Judge Namud or Judge Godoy or Judge Clement deal with it. And that will be something very interesting to be part of it. Zack differs from me. He says that will take a lot of time, and also it won't be the government itself. It will be maybe a governmental corporation or a municipality, which is different. He has a broader picture in what he is supposed to propose in the next few minutes.
Nelson has done a beautiful job of explaining why on page 22 here, if you don't use bankruptcy, federal bankruptcy power, you can't go beyond the limit that says states cannot impair contracts. Apparently, Puerto Rico has hit that limit because the last couple of times they've tried yet again to change labor contracts, the courts have said no. Move on to page 23. So assuming that Puerto Rico has had very substantial austerity in the cuts it's already made in labor, what can it do at this point going forward? You've heard this litany from me before. You can get a financial advisor and figure out how much you can reasonably afford to pay because you can't cut any further. Develop a plan based upon that. Have a meeting with bondholders and describe describe what you can afford to pay and show them the study and put it in the newspaper and make everybody on the island aware of what the study shows you can afford to pay. Assess whether it's necessary to have a payment moratorium to get them to go along with what is shown. Now, I just crossed the line. What is it that gets people's attention to take a deal where you're going to pay them less than in full? Payment moratorium gets their attention. Doing it is something that isn't done very often in these restructures. And once you've done it, there are enough bankruptcy lawyers in the room, you kind of have to be prepared to live off your cash collateral collections. Because once you've told the capital community we're having a payment moratorium, it's not likely somebody's going to come in and give you some new financing right away. What if bondholders are not willing to agree to the plan? D1, bondholders can find out just how strong their remedies are. Come on, try your mandamus remedy. We'll see you over there. See how far you get. And for a while, we will put up on a defensive basis with you doing that, but at some point, we think this plan is fair and equitable, and we will find a way to force it on you. That's what Puerto Rico can do, and that's what Greece can do, and that's frankly what Ukraine can do because they're really broke. That is the model of how the government leads in these things instead of having the capital community tell it how it's going to live going forward.
Zack, Mike.
I got it.
Sorry.
Thanks. What procedures are available to Puerto Rico? Nelson, you lead us through this.
Well, you kind of discussed some of them. Let me see, I cannot read it from here.
This is the one that talks about whether Puerto Rico is authorized under the federal statute to be a Chapter 9 debtor.
Well, that one won't work unless you do what I explained to you before, using a test case going forward to the bankruptcy court, attacking first the constitutionality of 10152, saying, you know, we are out of the loop and there's no rational test behind it, so we will try to do that first and then go on to see if we comply with the other part of the statute in Chapter 9. And we have tried, at least the government tried, some mechanisms of restructuring, and some of them work at the beginning in the case and in the courts, and the other ones haven't worked that well. That's when I went through the case law, including Supreme Court and First Circuit. And the last thing I discussed was what the legislature is trying to put together, which we don't know exactly what it is, but at least from my reading of the beginning of the first draft, they won't touch any contractual impairments.
So that law that's in the legislature, unless it is saved by this gentleman's 1890 old act that's out there on the books, will be constrained not to impair contracts.
Excuse me, I just forgot to mention something that is mentioned in the legislature, the proposed legislature, which goes back to what he mentioned in the civil code. And that the legislative intent in that piece of legislation that we read actually mentions and identifies what he's talking about, but it discards it entirely because it states that it doesn't have a mechanism, which is what Mr. Perez-Bax was explaining to you, that will allow this to go forward. So it's kind of useless and is recognized like that by that piece of legislation.
So all of that said, it looks like, yes sir?
I think the thing is that they didn't read carefully the civil code. First of all, the civil code provides for debtors and it doesn't make any exceptions. And in Spain in 2003, in order to forbid public institutions to go to bankruptcy, concurso, they had to approve a particular law. Therefore, we can do that. Second, under section 1812 of the Civil Code, it makes reference to the old Spanish procedural law, which was abrogated in 1979 by the Rules of Civil Procedure. What the legislature has to do is enact the procedures to complement the Civil Code, and they will not be bound by the problem of impairment of contracts, because this is a very old law.
Now, just for what it's worth, I consider you a patriot. and secondly, if you read this bill that Nelson showed to me last night, it says on its face that it shall not impair contracts. And so the bill that is being proposed imposes that limit.
Yeah.
Yes, sir.
Yes, I believe Article 2, Section 7 of the local constitution has the language against menoscalde.
Exactly.
So it has been legislated against.
So, sir, just like I hope Nelson wins his lawsuit about unfair discrimination in the federal statute leaving Puerto Rico out, I hope yours works too. But I've got a third one I'm about to describe. Move forward to page 25, and I'll fast forward through a little bit of this. Northern Marianas Island had a pension fund that it never funded. The thing was vastly underfunded, had about enough money to pay people 50 cents on the dollar. Tried to file a Chapter 9 case, was thrown out because of what I would call the technicality of, are you authorized by a state? The court praised them for trying to use federal bankruptcy law to fix the problem, and then the Marianas Fund did the following. They settled with the state their lawsuit to make the state fund. They settled with beneficiaries about how much they would pay, and they did a settlement agreement and asked to have a federal equity receiver appointed to implement the settlement agreement and, frankly, to try to bind holdouts. So how did they solve the problem after they were told they couldn't go to bankruptcy court? They did a federal equity receivership. And we'll come back to that here in a moment. Federal equity receiverships were developed in the late 1800s when they were building railroads all across America, and the way it worked in financing was people would finance 10 miles of track. And those 10 miles of track would be worthless unless they were part of something that went all the way, for example, from St. Louis to Chicago. So what happened is the federal courts developed a procedure where when the first foreclosure sale occurred, or motion occurred, the receiver would be appointed to preside over the whole railroad and try to preserve its going concern value. And every one of the concepts that we have in the bankruptcy code now about feasibility, best interest of creditors, and fair and equitable came out of federal equity receiverships. Congress simply later codified what had been going on in federal equity receiverships, and they codified it for railroads and they codified it for corporations. But the law was developed by federal courts doing equity in something that had to be done to preserve value in a developing economy. (903) and 904 give us some guidance to what you would have to do if you went forward with a federal equity receivership. Because implicit in the Beckons case, forget implicit, explicit in the Beckons case is, can a state send its child, a municipality, over to federal court to use federal bankruptcy law that permits impairment of contracts? The answer was yes, as long as the state basically keeps control of its child, that is the municipality, on political issues, and as long as the federal court can't tell the municipality how to run its business. And so if you were going to use a federal equity receivership in which a state or a commonwealth came to the federal court and said, we want you to run an equity receivership and apply the fundamental principles of feasible, best interest, and fair and equitable, it would be really wise to do it in a way that met what Beckons taught us. I'm going to let Nelson tell us what Beckons taught us.
I thought you were going to do that, but that's okay. Well, I think what you're trying to do here is saying, since we cannot use Chapter 9 as the law stands right now, we can use Beckons to take care of us and go forward to the Supreme Court. I'm sorry, to the District Court, asking for some relief. Is that basically what you're trying to do?
Well, Nelson and I, we tried to choreograph this. The only part of the burden I want you to carry is the part that says, well, what does Beckons say? And I'll help on this. What Beckons says, if you read through this, which is really hard to read unless you're in the first row, what Beckons says is, the state has a problem. It has a broke municipality, and it can't fix it because it can't impair contracts. But the state can, in order to fix the problem of its municipality, consent to the municipality filing a Chapter 9 case, or it wasn't Chapter 9 then, filing a federal municipal bankruptcy case, as long as the state gets to continue controlling the politics of the entity, and as long as the federal government doesn't tell, or federal court doesn't tell the municipality how to run its business. That's what Beckons holds. That's what it holds. Now, honestly, it holds it in a context where a state is talking about its child. And I found it useful to say where a parent is talking about the 17-year-old son who wants to join the Marine Corps. You're going to sign the papers and let him join. That's what Beckons was about. Now, what I'm pretty obviously about to talk about is when the parent decides it wants to join the Marine Corps. Could Puerto Rico pursue a federal equity receivership? I didn't know any better way to say it than the first sentence. It would be novel, and I thought it would be hokey to put 9 exclamation points. But think about what I said about federal equity receiverships concerning railroads. There was a phenomenon in the country, railroad expansion into the West. If they were foreclosed upon, they were largely worthless. You had to keep them together as a unit in order to be worth anything. And the federal courts, I believe, exercising federal bankruptcy power that had not yet been codified by Congress, but I want to check further to be sure that I'm correct about that. The federal courts and equity receiverships developed all the law that is now there in our bankruptcy code about fair and equitable, best interest, feasible. What do we have now? There is $3.7 trillion of outstanding municipal bond debt on municipalities in America, and I think that includes Puerto Rico's debt. 3.7 trillion, that's about 1/5 of the national debt without any military to run the number up. Unfunded pension liabilities, about 1.5 trillion. Between the two of them, $5 trillion, that's 1/3 of the federal debt. We have a huge problem. In America, they have the same problem all over Europe, but in America, this problem is largely the problem of children of states, otherwise known as municipalities, but in some states, it's the problem of the state itself. There's one state in particular that's really broke. There's a large city in that state that is the most, got the worst numbers in America. I'll just stop short of saying that. The federal courts need to find some way to help address this problem. And so, how do you try to fit yourself into this? We could talk about filing a plan on day one, talk about limiting the duration of the receivership period to about 6 months, You talk about the only reason we're here is to have the court adjudicate whether this plan we brought in is fair and equitable so they can be binding upon holdouts. And you do it in the face of the best authority I know, which is 1, Beckons, and 2, there are 2 footnotes in my article that talk about how federal equity receiverships went and what law they developed. And you effectively say, relying largely on Beckons and on the fact that once before the federal courts dealt with problems in bankruptcy where there was no statute, but they made up equitable remedies that were so good the statute later copied them. And you ask the federal court to solve the problem in a 6-month period and have a trial about whether your plan is fair and equitable. Now, I'm going to repeat the first point. Is this novel? Yes. At the moment, the only thing I can cite to as support for doing this is Beckons, but if you read Beckons, I submit to you, you'll see it largely cries out for some such approach as this, at least if you add to it the notion of pursuing a federal equity receivership. And so I've tried not to make any jokes about this while I was talking about that part, but I will get to the end. As a governor candidate in Texas said, why the hell not? Why the hell not? If the alternative is to sit passively and be told to have more austerity and more tax increase than you can take, which is what frankly is happening in Greece right now, why the hell not lead? Why not do a debt restructure and cash flow study to determine how insolvent you are? Why not do an affordability study to determine how much further you can cut things? Why not develop a plan based on this? Why not share this study with creditors as a premise to asking them to agree? And if they're holdouts, assess what can be done. That is a really nice verb for think about whether you're going to get their attention through a payment moratorium. That's how you encourage them. And decide whether you want to take the risk of doing one of 3 things. What Nelson described beautifully, what the gentleman in the back here described beautifully, or the one I just described. But fundamentally, this may be the 15th or 20th time I've said it, why not lead with a fair and equitable plan? And I think it's important to say a little more about that than just saying it. Behaving like you're leading makes a difference. Behaving like you're leading leads public opinion. It leads the other side to think these people are resolved. It leads the other side to think these people have something they believe in when they say repeatedly, this is all we can afford to pay. It leads people to believe, frankly, they better make a deal with you. Thank you.
Thank you.